I'm delighted to be back at Swarthmore, receiving another degree. My teachers, especially J. Roland Pennick and Frank Pearson, prepared me well for a career in the legal academy and, as fate decreed, on the bench. I owe them more than any form of words can express. Despite saying that, I want to use my brief time today to disparage a view that's common in today's academy, the attitudinal model of judicial behavior taught in both political science and economics, which asserts that decisions reflect the judge's background and politics, or perhaps just the views of the presidents who appointed them. We have about a month to go in the Supreme Court's current term. Many 5-4 decisions surely are impending. The press will bemoan the justices' inability to agree and assert that the justices' ideology must explain the divisions. Those of you who have encountered the attitudinal model in class will nod sagely. You and the press will be wrong. Suppose the justices who are usually called conservative were to resign tomorrow and all be replaced by President Obama. The reconstituted court still... Oh, maybe I should have said all the justices who were liberal were to resign and be replaced by President Romney. No. I just want you to imagine a court all appointed by the same president. That reconstituted court would still find lots of cases to be hard. It has discretionary review authority, and it would grant review of those cases that it thought hard and decide many of them 5-4. Cases that the current court finds hard and decides 5-4, this hypothetical court would find easy and decide 9-0. But lawyers would then stop presenting those disputes. They would bring more and more of the issues that divide whatever court is then sitting. To those of us who specialize in economic analysis of law, the effect is known as selection pressure in litigation. The choices made by lawyers and the choices made by a court with discretionary review authority ensures substantial disagreement even when there's no ideological difference among the judges, which also makes it very hard to blame politics for the disagreement we actually observe. The rate of disagreement among the justices has been stable for more than 70 years. The court has the same rate of dissent now as it did in 1945, though in 1945, 8 of the 9 justices had been appointed by a single president. Selection pressure is responsible for this stability. Those of you, regardless of your discipline, shouldn't find disagreement hard to understand. Is Pluto a planet? Astronomers answered no by a closely divided vote. Is Einstein's theory of general relativity right, or should it be replaced by modified Newtonian dynamics? Should string theory replace the approach known as the Standard Model? Scientists disagree about these and many other questions. There's no need to resort to ideology or politics to understand disagreement among specialists who tackle a discipline's hardest questions, which is what the Supreme Court does. Given selection pressure in litigation, the puzzling feature of the judicial system, the genuinely puzzling feature, is agreement. There's much more agreement than the attitudinal model, or anyone who has read Wittgenstein and other language skeptics can explain. Judges of my court agree in 97% of all cases. The Supreme Court has a lower rate of agreement because it has more judges assigned to each case, 9 instead of the 3 that sit on each case in a court of appeals. Yet the Supreme Court decides about 40% of all its cases unanimously, and those are the very hardest cases in the legal system, which usually reach the Supreme Court because judges of other courts were at odds. And it isn't just technical cases that end unanimously. Last January, the Supreme Court decided Perry against Perez, a reapportionment case that concerned how many districts in Texas will be drawn to favor Hispanic candidates. All 9 justices rejected the contentions of the Obama administration, representing the political left's perspective, and all 9 rejected the contentions of the state of Texas, espousing the rights perspective. Both state and national politicians and editorial writers had strongly disagreed about what should be done in Perry. The justices resolved that case unanimously. Here's another example. Last Monday, the Supreme Court considered whether a child conceived through in vitro fertilization after the father's death is entitled to benefits on the father's account under the Social Security program. This question had divided appellate judges. Many articles in the press, the legal press, legal blogs, as well as the popular press, depicted the case as an opportunity for the justices to express their preferences about religious versus scientific views of conception and family status. But the justices saw it only as a dispute about the meaning of statutory language. The case was resolved unanimously. Something other than ideology produces this remarkable degree of consensus in the legal system's toughest cases. Judges reach agreement even when selection pressure says they shouldn't be able to. You should therefore think better of the judicial system than the editorial pages do. In the United States, the rule of law really does differ from a rule of judges. Neutrality is a comfort to all of us who must stand before a court and to all of us who favor equal justice under law. You should keep this in mind as you encounter the legal system, whether as a participant or as a reader. And if someday I meet you as advocates or students or colleagues, I look forward to the opportunity. Thank you so much.